SJC-13821, William E. O'Connor versus MAG Mutual Insurance Company.
Attorney Trundy.
Good morning, Chief Justice, Associate Justices. May it please the Court. Christopher Trundy for the plaintiff appellant, William O'Connor. We are here asking you to reverse the determination of coverage, which was entered in the Superior Court, and we believe was in error because the actual policy language very explicitly covers the nature of the insurance.
Can I ask a time question? So the policy is entered into in 2019, right? The last medical treatment he provides for the woman at issue here is in 2016. I'm having real trouble getting around that fact, okay?
Well, so the
everything that happens after 2019 has nothing to do with medicine. It has to do with stalking and other things. So,
well, those are two different things. If you
but go ahead.
don't mind my
I'm
saying
just
so.
putting my thoughts out for you.
So one of the salient points in this case is the big difference between a claim, which is a negligence malpractice claim, which was never made in this case. And of course, that date and timing you're talking about make any of that sort of irrelevant under a statute of limitations analysis, but also under the policy analysis for a claim. Dr. O'Connor never tendered a claim. He was never presented with any claim for damages and so forth. This separate provision of the policy, which is sort of a standalone benefit, and I don't know the history of it at all, but for regulatory defense, simply says that if we will defend you in any investigation or administrative proceeding that implicates your professional activities.
Could you read that exact language? Because I thought there was more to it than that. Is this Q that we're writing, providing or failing to provide medical professional services by you to a patient, including blankety blank? It goes on, professional activity includes claims for civil damages resulting from your violation of law governing the standards of care in your medical practice and your duties to your patient, but does not include claims of any law acts which are in violation of any other law, statute, ordinance, or regulation. Isn't claims backing into that part of the provision?
Well, and I think here's what happens, right? You have claims under the body of the malpractice section of the policy. You have regulatory defense over here as something which I look at as sort of a rider or an extra bit of coverage, which has a limited dollar cap and so forth. They both import this definition of professional activity. And when you read that definition, you'll see that it specifically excludes, in relation to a claim, those things which would be consistent with actually what the judge did in her analysis, and which goes back to this court's decision in the Federal Insurance Row case that says, the doctor's sexual abuse of a patient in the course of treatment, a dentist in that case and several other cases, would be excluded. When you read that section on professional activity, you see that that's putting a limitation on damages. It specifically says we will not pay damages. The thing about this is that this case is not damages. It's not a claim. It was never claimed to be a claim. There's the defendant and the trial judge, it was a kind of a mini trial, both refers to there's no claim. We never asserted a claim. All Dr. O'Connor said is, I'm the target of an administrative complaint that implicates my activities.
Well, let me push you on that.
Sure.
So is the act of the doctor writing a script And the allegation is here is that it was to manipulate a personal relationship.
Sure.
So is a doctor writing a prescription to somehow manipulate some personal relationship? What makes that professional services?
Well, the allegation is that in the course of writing scripts, he did something wrong, right? But the defense is against allegations in an administrative context of doing something wrong relating to a professional activity.
Yeah, but that's not really getting to Roe's requirement that there's a causal relationship between the medical services and the harm.
So let me just say this. I would suggest to this court that Roe is inapplicable to your analysis in this case, because this is about defending an accusation at an administrative level. Roe was about a dentist who had already admitted.
Right. I know you're drawing the distinction between that, but we're still
and
looking
it was
at that.
about whether or not we're paying damages in the course of a medical negligence context. And so what we have here is a classic allegation made at the outset that you tender to your insurer, and they look at the nature of the allegation.
Right.
We don't know that whether the allegation is true or false. What he bargained for was a defense of an allegation made against him relative to his activities as a doctor brought to the Board of Registration in Medicine, and that's what he did. Now,
But that's what I'm getting at.
Because
what is your best support for the fact that a doctor might be writing a prescription that's unrelated to medical care, but only to enhance his ability to manipulate a personal relationship, that is somehow within the context of professional services?
Because one, it's an allegation. Two, even if you read the appellee's brief on this, there's no claim that he did something that was established that caused an injury to anyone. The claim is by indirectly from this patient that years before he had written prescriptions while they were in a relationship, and somehow there's no support for that. There's no analysis. That's an allegation.
But the allegation isn't that she was harmed by the drug that was prescribed.
There's no
The
such allegation.
allegation is that the conduct of your client was, I think it was sexual assault or something to that effect.
No, the allegation is that he acquiesced to her request to write prescriptions for her that she wanted as
Which
a way
were not harmful to
as
her.
a way that she had already had from another doctor, along with one from
As a way to,
acetaminophen or something,
as a way to,
as a way to keep her in an existing relationship.
the harm is that relationship.
Well,
I'm not saying it's
No,
true. I'm just saying that's what's alleged.
I'm just going by that's the thing that brings this to the Board of Registration of Medicine.
The thing is the harm to her from the extended relationship that he prolonged through prescribing drugs that did not cause her harm. The harm is the relationship.
Well, that's not what it says. It just says that he used these drugs to keep her in a relationship.
4 years earlier.
Yeah. Oh, no,
See,
no.
I just find that causal link has to break at some point.
Well-
Not only does the drugs not harm her, but the drugs are 3 or 4 years before these stalking incidents and everything else.
Right.
It just seems like we're bootstrapping stuff that has
but I-
incredibly remote. 4 years before he bought this policy.
So I understand that, but the policy did not exclude on the basis that there's an administrative complaint made at this point. For whatever motivations, whatever, we don't know what is going on in with the people who make the complaint. But that's his policy. He has a defense mechanism in the policy. So he's tendering it when he gets notice of it. I don't think there's any thing in the policy that
what's the limit?
excludes that simply because it's 4 years old.
What's the limiting principle on the breadth of the policy coverage, though? So if this had been conduct, if the conduct here had occurred without the doctor writing the prescription, would it be covered?
I'm not sure I can follow the hypo.
Well, doesn't the harm have to be medical harm?
No, it doesn't have to be, because you can claim that in your interactions with a doctor that they engaged in any numerous versions of unprofessional conduct that can trigger an administrative proceeding.
Sure.
Malpractice. It covers
But it's not
malpractice.
yeah, but this isn't malpractice. There was not a claim of malpractice. There's a claim of doing something wrong in using prescriptions. That's a core activity under the definition used in Roe.
I would
of
find this more
doctor's activity.
If it were contemporaneous, I could see it having some possible relationship. But the fact that it's so old,
Can I ask a question in relation to that? Is there anything in the rules of the board that regulates the practice of medicine that limits the board from investigating a complaint that a doctor is writing prescriptions for impermissible purposes?
Not that I'm aware of, and they proceeded, and he defended himself at his own expense in this case. It was not simply dropped. This was, it was brought to his attention after a summary suspension.
So the fact that it was 4 years, the fact that it was 4 years earlier that he was alleged to have written prescriptions for an improper purpose did not change the fact that an administrative proceeding of the agency was going to go forward.
Right, and I think what's important is that among the other unrelated stuff that's in this complaint, that standing alone may or may not have intrigued the board, but this claim about the writing of prescriptions, I think, is the core interest of the Board of Registration in Medicine.
no, it's not. If doctors are stalking their patients, they don't want them to be doctors.
Well, I understand that.
It's not just the medicine. If he's stalking them, and they clearly have a right to intervene for those purposes, don't they?
Well, I agree, but what I would suggest to you is this, that we have to look at the complaint as made. Now, those are allegations. Obviously, Dr. O'Connor is looking to contest those, which he does, but he's asking his insurance company, who he has a contract with, to defend him, which they don't. They deny it on the basis that it's not a malpractice claim at that point. He then expends money for defense, and then we bring this action, and now we have a second explanation, which is, this is no longer professional activity. And so the claim that only to defend somebody for an administrative proceeding where they're clearly innocent, or you can prove you're innocent before the insurer steps in, doesn't make any sense.
I think the argument is that it's just not covered,
Right.
regardless of innocence or guilt.
I'm sorry that who's
That
not,
this regulatory process, because of the nature of the claims against the doctor, whether or not true, don't fall within the policy language. This is not, I don't think the insurer has determined guilt or innocence. I think the insurer is just looking at the language of the policy and saying, you
the
don't
policy
fall.
does not exclude on the basis that there are accusations that would, if they were a malpractice claim, not result in indemnification.
I don't
I think if you look at the two provisions, which is the regulatory defense and with a limited reading of the professional activity as it applies to the regulatory defense, that having this claim about prescriptions squarely falls within the policy coverage.
Do you agree that our determination is whether or not what's been alleged, and that allegation again is that the doctor wrote these scripts to manipulate this personal relationship, that our determination here is whether or not that falls within the definition of professional services?
Yes, I agree with that.
And what's your best case that it does?
Because it's writing prescriptions. And by comparison to all of the cases that are cited, every one cited by the defense is an indemnification denial case.
Well, actually, isn't it true that Hearst actually comes out your way on the defense point? Hearst rejects indemnification, but finds that they're,
Yeah, but
that they were on the hook for defense.
yes, yes. And
So what's the limiting principle here for people going forward? That just the act of writing a prescription untethered to any kind of medical diagnosis or treatment or harm triggers coverage?
so what I would say is this. The act of writing a prescription is a doctor's act. What you make of that, whether that is done for some ulterior motive or so forth, is different than the cases where a dentist uses medication to subdue a patient and then engages in a separate act of assault. So I would say that that's how they differ. One is a standalone fact. He issued prescriptions. What does that mean is what the process is going to be about. It may mean that it's completely innocent, completely appropriate. If it is, then he should have been defended, we would think. But we don't know at the outset. So I would say there's reasonable susceptibility to coverage. Thank you. I'm almost out of time unless there's something else. And I know we've had a long day, so I'll get out without extra time.
All right, Attorney Ennis.
Good afternoon. May it please the court. Sean Ennis on behalf of the appellee, Mutual Insurance Company.
Can I ask you, I'm sorry to cut you off right at the beginning.
Certainly.
Can I ask you, just to help me with my own understanding of what I think the policy is and is not doing? So I understand the regulatory defense provision, which is the provision at issue here, and then insofar as it incorporates the definition in section Q about professional activity, to be a duty to defend provision, correct? It doesn't provide for indemnification. It's not a duty to indemnify. Am I correct to that extent?
You are correct.
Okay, so now can you please talk about the difference between the duty to defend and the duty to indemnify? Because I do see a big difference between those, and namely that there's not really a testing of the truth of a claim when it comes to triggering the duty to defend. So I'd like you to sort of expound on that, because I think that may be where the rubber hits the road in this case.
You are correct, Your Honor, that the duty to defend, and this does not fall squarely within most of the duty to defend cases, because those are brought up in the context of claims and lawsuits where there are two duties: duty to defend, duty to indemnify. And it's well-settled law that the duty to defend is broader than the duty to indemnify.
Right, here we have no duty to indemnify. So we're, and that, to me, it makes a difference, because the liability of the insurance company is going to be capped just to defense costs, right? So it makes sense in some ways that the scope of the duty would be interpreted broadly, because the insurer's exposure is going to be less. So here, when we take, if all of that is true, then we take, do we use the ordinary rules of construction that we have used in other types of insurance contracts with respect to the duty to defend, and how we measure it against the scope of the complaint that the insured is looking to be defended against? Do we use those same cases? Because if we do, I'm wondering why it is that the duty was not triggered given this complaint.
And assuming we do use that same duty analysis, the duty to defend in the indemnification duty cases, I submit that even using that standard, what you need to do is match the allegations with the policy language. Just hold up the allegations, hold up the policy language, and see, do they mesh? Does this fall within the coverage? And I submit it does not for this reason. The policy provides that there's coverage for a regulatory proceeding such as this, where the complaint arises out of a patient complaint about the insurer's professional activities, i.e. medical professional services. And in this case, this was filed after, if you look at sort of just the timing of when this complaint was lodged with the board, it was after Dr. O'Connor was allegedly violating a restraining order, engaging in this stalking behavior.
Right, so
stealing mail.
none of that would be. But then there's the paragraph, because the December 24th, 2019 letter is incorporated into the complaint. Then there's the paragraph where he says, well, on top of all of that, the stealing the mail, the this, that, the other, he's been prescribing an addictive drug. And now it does say that he's prescribing it for a purpose. That purpose would be not a covered purpose because that's not a medical service. But why is it under our liberal construction of the duty to defend that that the duty to defend is not triggered by the allegation about the act of prescribing, which is a medical service?
But you need to look at the allegation, the allegation, and the allegation here includes the alleged illegitimate purpose of the medication. There's no allegation that this was prescribed in the course of Dr. O'Connor's treatment of this patient.
That's a factual dispute issue, because he's going to argue that I was giving her this medicine for good reason. That's why I kept coming back to the timing issue, which is there's such a great time lag, but you don't seem to care much about that. And that's what bothers me about, because if we do just what Justice Wolohoja said, is we look at the allegations, but we don't look at the truth of them. His defense is going to be, I prescribed this medicine because she needed it. But it was 4 years ago. It has nothing to do with now. So that's where I was focusing on time, but you seem to have dropped that in the case at some point.
So the
That's where
issue
I
with
get lost.
I'm happy to address that, Your Honor, and that is a very good point with respect to the timing. The issue, why this is not a thrust of my argument is, well, one, because the time, when you look at the retroactive date of the policy, that applies to claims. And I think we're on the same page with respect to, this is not a claim, it's not a lawsuit claim for damages. The date applies to a claim. There is no date, a retroactive date written into the board coverage portion of the policy. But I submit that the timing of the allegation is relevant to determining whether or not this complaint arises out of medical professional services, because it was filed years after the patient's treatment stopped, years after those medications were written. What triggered this complaint, what this complaint arose out of, was the alleged criminal stalking behavior and activities and all of that.
It's both, right? It's both, right? There's a ton of stuff that's not medical treatment, and then there's this one allegation about the prescription. Is there a helpful case law out there that involves what I would call a mixed situation, where a bunch of the stuff is clearly not within the realm, but then there's one small piece that maybe arguably looks like it's a small part of it, but is within the realm?
I don't have a cite to a specific case.
Well, isn't Roe such a case where there's Novocaine prescribed to the patient during one of the incidents?
Sure. In the Roe case, Your Honor, and that was, I think that was correctly relied on by the trial court in deciding this case. It doesn't
It's not
It's not a duty to
talk
defend
about
case.
the Novocaine, but that's a central issue, because it's saying, look, this intentional tortious criminal conduct, clearly not medical professional services, same definition here. And it's sort of hinted at, but at least once after the administration of Novocaine. And that's why I'm citing to these sexual assault cases in other jurisdictions.
But that was a duty to indemnify case, correct?
Well, there was one case that did talk about.
If we talk about the duty to defend cases, just insurance cases generally, I think when there's mixed allegations, the duty to defend is still triggered, correct? You don't get to say we're not going to defend because some of the claims in this complaint fall within the duty to defend and some don't. You still need to pick up the defense. Why would we use a different rule here?
You're absolutely correct, Your Honor, and I'm not suggesting that we use a different rule. I'm suggesting that you need to look at what the allegation is as it relates to the prescribing. And it is not an allegation that these are prescribed for medical treatment of any kind or for treatment of a condition. There's no claim it was negligently prescribed, that she suffered harm, that she was, all you can.
Well, the allegation is that the victim feels that the doctor used the addictive qualities of the drug, right? So the secondhand allegation is that the property of the drug is being misused. So why isn't that just like bad prescribing practices that we would, if the allegation were my doctor was overprescribing an addictive drug to me in order to keep me addicted without any leverage component to it, just for another purpose, just saying, was overly prescribing an addictive drug. Would you agree that would be covered under this regulatory defense provision?
If that's the only, it may very well, Your Honor, what we're dealing with here is allegations of intentional behavior. I think that's where the line is drawn. This goes beyond, in some of the cases cited in our brief where there was a duty to defend found, are very different than this, because in those cases there was specific allegations that of negligent medical care. One of them, nitrous oxide, was prescribed at extremely high doses. The dentist failed to properly monitor it or have a system in place to check the monitoring of it. So that's medical negligence, and that triggered the duty to defend.
What about the overprescription of for purposes alleged to be like insurance fraud? Just your prescribe whatever. Would that be covered?
I would submit that it's not, Your Honor.
Why? How?
It's intentional, wrongful conduct.
But don't you need to dive into the facts in order to know whether it was or wasn't? And that's contrary to the exercise that you do in measuring the duty to defend.
I submit it's not, Your Honor, because if you look at the duty to defend, the Liberty Mutual case, the test for determining the duty to defend is based exclusively on the facts as alleged, rather than the facts as they actually are. So you have to look at what's alleged.
So yeah, can you go back to the Hearst case? Do you think, you've cited for the first part of the opinion, which is about indemnification, and you've not addressed the second part of the opinion about duty to defend, where the court said even though they didn't have to indemnify, they did have to defend. And it's kind of similar that there's a prescription of drugs, and at least if you just looked at the four corners of the complaint, which, the court commented, it turned out to maybe not be true. They stated there was an allegation in the complaint that he prescribed the doctor prescribed contraindicated drugs and medication to render the victim susceptible to the doctor's actions and failed to follow proper standards of care. I realize that's more detailed than what we have here, and perhaps that's what you're about to argue makes this different, but it's similar in that there's a allegation in the complaint that there was improper prescribing practices.
Right, but that's phrased in the sense of medical negligence, improper standards, falling below the standard of care.
So you don't
That's what's alleged here. If this complaint was he prescribed medication that was contraindicated for the patient's condition, that caused her to suffer a reaction, and it's related to medical treatment, medical professional services. That's what it all comes back to. I agree that would be covered.
But isn't that assuming things that are not in evidence when you're looking at the four corners and trying to determine whether it's it reasonably involves treatment, right? They looked it up. The investigator looked it up. There was a whole record of prescriptions from this doctor to this patient. This doctor was providing this patient with these prescriptions, right? And so there was going to be a fight about whether it was proper or not proper, correct?
But the allegation, again, I keep going back, you have to look at the allegation, and the allegation here is that it was done for an improper purpose, an intentional improper purpose.
Where does the intentional come into the policy? You keep referring to this being different because it was intentional, and that's the allegation, is that it's intentional. How does that relate to the policy language? Why does that mean that it's excluded?
Because it's not, at this point, it's not medical professional services.
So he's writing a prescription, but he's not writing a prescription.
He's writing a prescription, but it's not for the purposes of treating the patient. for the purposes, if it's.
But that's
it
the
facilitates
allegation.
wrongful
That's the
conduct.
allegation, is that he's writing it for
Exactly,
purposes
and
that are
that's what
not.
we have to look at, is the allegations. That's all we have to look at.
Attorney Ennis, can I ask you a different question? Because Attorney Trundy said this, and you said this about 5 minutes ago. I didn't see this really dealt with in the briefing. Another reason why the trial judge found in your favor was saying that this wasn't a claim. And you both got up here and said, this isn't a claim. So can you just help me with this? I mean, so the trial judge said it's not a claim and it's not professional services. You both get up there and say this isn't a claim. So why are we here at all?
The claim, one way to get to trigger the professional liability coverage is if there's two ways. One is if there's a complaint that arises out of a covered claim. So, for example, a medical malpractice lawsuit is filed or a claim for damages is filed. That leads to a board complaint. That's one way to invoke that coverage. The other way is a complaint brought by a patient.
Which this isn't.
Which is, it's not. It's actually the husband of a
Right.
patient. This was an argument I had raised below, but I agree. I think that would be an overly restrictive interpretation of the policy to say just because it's the husband and not the patient, because these things do get to the board in a number of different.
Now I'm getting confused, though. Can you go back to my original question? So if you've got a 4-year-old prescription issue, does that not matter in this context? Because I'm starting to wonder whether you're right. If this is about just, if that timing of the prescription stuff doesn't matter at all, this is a fight about whether he gave medicine improperly or properly. So does the timing not matter? Am I on a wild goose chase here?
I think it matters because it speaks to what was the impetus behind this complaint. Does this complaint arise out of the stalking behavior or arise out of the medications that were prescribed?
Yeah, but we don't, that can't be how we define duty to defend on impetus. Because
Well, don't you look at the gravamen of the complaint? And the
Exactly.
gravamen of the complaint here is that he was stalking and he was doing all this other activity. And in addition, 4 years ago, he prescribed a addictive medication.
Exactly.
The gravamen of the complaint is not that that medication caused an addiction or was somehow improper. It's that the conduct of which this 4 years ago prescription is part of is what caused the harm to the patient. And
You're absolutely right, Your Honor. You said it better than I did. But that is, if you look at the gravamen of the complaint, and Roe talks about the gravamen of the complaint as being.
it isn't, again, we have, when we're doing duty to defend, if 3 things are ridiculous and 1 thing is covered, you have to defend, right?
That's true.
So this gravamen idea is very interesting, but it's the gravamen of that portion that we got to focus on, which is her husband says that he prescribed medicine to basically get her dependent upon him. Isn't that the gravamen of that part of this thing? And does that fall within coverage? Because I agree, the 3 things are ridiculous, but our case law says if 1 thing is covered, you got to defend all 4, right?
Correct, Your Honor. In the gravamen
So
of.
help me out here, because this is important, at least to me, how you answer this.
The gravamen of the complaint as it relates to the medications is that they were prescribed essentially to facilitate the doctor continuing inappropriate relationship, which is not medical professional services. That's what you have to look back at the policy language and what's being alleged with respect to the medication. So it suggests that in the context of this case, it's a narrow issue that this court needs to decide, is the interpretation of this policy based on this complaint. I submit that the Superior Court correctly ruled that there was no coverage for this policy or for this complaint, and I would ask that the judgment be affirmed.
Thank you.
Thank you.